Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 86th lecture. It is our regular practice that we recite preamble of the Constitution of India because we strongly believe that preamble our identity, preamble our dignity, preamble our commitment, preamble our sentiment, preamble our goal, preamble our soul, because our founding fathers' vision is to achieve those goals enshrined in the preamble. And it is our duty today to have the preamble as our mission to achieve many more things. Still poverty is there. Still unemployment is there. Still people are crying for justice, crying for food. So therefore, our duty is not only to reciting preamble, but see to that in daily routine, how do we realize in real terms? That is very important, dear friends. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. In lecture number 85, the previous lecture, we have discussed about the overview of the entire judgment. But that is not enough. I want you people to see what are the relevant paragraphs, because I am going to refer to SEC, that is 2024, volume 6, SEC, page 1. I will take you to the relevant portions of the judgment. Please make note of such paragraphs. We have spent almost 1 week to identify which is the heart and soul of the judgment. If you are going to write that, and if you are, what is the difference between clearing an advocate on record examination and getting a gold medal, dear friends? Getting a gold medal means you have to establish yourself that you are an outstanding student, right? But you cannot go there and you cannot say your answer sheet should reveal that you are an extraordinary student. How to make yourself an extraordinary? How to convey? Yes, you have to give some quotations, very important quotations. You remember 10 quotations, 15 quotations, and you can apply those quotations. For example, Justice Krishna Iyer, celebrated judge, in one of his judgments, he has said, it is not only the politicians have constituency, courts also have a constituency. What is that constituency, dear friends? Nation is the constituency for the courts. Even courts have manifestos. What is the manifesto for the courts? Constitution of India is the manifesto for the courts. How beautiful these lines are. If you are going to quote this in one of your AOR papers, wherever it accommodates, you will get wonderful marks. In similar situation, again Justice Krishna Iyer talked about prisoner's right. Prisoner in a jail was assaulted by the jailers, was ill-treated by the jailers. They are approaching the court. In that celebrated judgment, Justice Krishna Iyer, my lord, saying like this, giving a verdict like this, beautiful lines. You should understand, dear friends, from their angle. Justice Krishna Iyer, my lord, has said, prisoners, by being a prisoner, they have not given farewell to their fundamental rights. How beautiful these lines are. Being a prisoner, they have not given their farewell to their fundamental rights. They ask a question, where is the prison? Prison is in Indian soil. What is the law ruling the Indian soil? Constitution law. Constitution law provides basic fundamental rights even to the prisoners. If there is any assault to the prisoner, if there is any humiliation to the prisoner, our writs, we will issue a writ. That writ will run through the bricks and break the iron walls, iron bars, and set him liberty. Ensure justice. How beautiful these lines are, dear friends. This will come only with pain, when they feel the pain of the litigants, prisoners. Like this, if you are going to write, nobody will deny you good marks, dear friends. So please remember these quotations. And one of such quotations with respect to professional ethics, Justice Krishna Iyer has said, we have Bar Council of India rules, but it should not remain only in rule book. It should be applied in our life also. So these lines you have to memorize. Whenever you are after your dinner, after having a mild walk, instead of Instagram or WhatsApp, you have to, whenever you talk to your friends, you can always say, what is the quotation about prisoners' right? What is Arbitration Act? Is there any quotation for Arbitration Act? When you start your answer with these quotations and giving your personal opinion at the end of each question, that will show you are an extraordinary student. So now coming to the relevant paragraphs, dear friends, I am going to take you to the relevant paragraphs. Please make a note of it. Now we are going to see the purpose of Arbitration Act. It is at page 56, para 67. Page 56. I am referring to SEC, dear friends. 2024, volume 6, SEC, page 1. Page 56, para 67. This is one such quotation, dear friends. Sorry, sir. The same judgment, interplay. The name of the judgment is Interplay between Arbitration Agreements under Arbitration and Conciliation Act 1996 and Stamp Act 1899. This is AOR revised serial number 76. Dear friends, in this one paragraph, they have explained the entire purpose of the Arbitration and Conciliation Act. Let me read it for you. Arbitration is a method of alternative dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. The aim of arbitration, dear friends, this is where you have to write it. The aim of arbitration is to provide speedy, efficient, and binding resolution of disputes. How to remember this? SEB, like that, speedy, efficient, and binding resolution of disputes. that have arisen between the parties in regard to their substantive obligations. So this is the purpose. The thrust of arbitration law, see, I am talking about quotation now, dear friends. If you are going to write this, you are going to get good marks. The thrust of arbitration law is succinctly encapsulated in Redfern and Hunter, name of the authors. What they say is, this is poetic lines. It is to be expeditious where the law is slow. They are referring to arbitration. It is to be expeditious where the law is slow, cheap where the law is costly, simple where the law is technical, a peacemaker instead of a stirrer up of strife. Strife means dispute, conflict. So it is arbitration is a peacemaker, arbitration is expeditious, arbitration is cheap where the law is costly, arbitration is simple where the law is technical. So therefore this is the arbitration. So when you are going to quote this, definitely it will definitely influence the examiner to give more marks. No ever will write like this. This shows that you are an outstanding student. Now, what we have discussed about arbitral autonomy. Where will you find it? Page 57, para 73. I repeat, page 57, para 73. Arbitral autonomy means that the parties to an arbitration agreement, I repeat dear friends, arbitral autonomy means that the parties to an arbitration agreement can exercise their contractual freedom. See how beautiful lines are. We know freedom of speech and expression. This is contractual freedom to bestow the arbitral tribunal with the authority to decide disputes that may arise between them. The basis of arbitral autonomy is to give effect to true intention of the parties. So they are talking about two things. One is giving effect to the intention of the parties and respecting their contractual freedom, distancing themselves from the risk of domestic judicial parochialism. What does it mean? It requires minimum judicial interference. The court should restrain from exercising its authority until the award is passed. This is the meaning of it. Because the arbitral tribunal has got entire authority to decide on its own jurisdiction, to decide on the existence of the arbitration agreement, to decide whether it is a valid agreement or not. Everything it can decide. Court should wait until the arbitral award is passed. This is what the essence of arbitral autonomy, dear friends. Now, principle of minimum judicial interference. You will find at page 62, principle of, this is heading dear friends, principle of minimum judicial interference. Page 62, para 88 and 89. These two paragraphs will explain us about the minimum judicial interference. One of the main objectives behind the enactment of the arbitration was to minimize the supervisory role of courts in the arbitral process by confining it only to the circumstances stipulated by the legislature. For instance, Section 16 of the Arbitration Act provides that the arbitral tribunal may rule on its own jurisdiction, competence, including ruling on any objection with respect to the existence or validity of the arbitration agreement. The effect of Section 16, bearing in view the principle of minimum judicial interference, is that judicial authorities cannot intervene in matters dealing with the jurisdiction of the arbitral tribunal. Although Section 8 and 11 allow court to refer the parties to arbitration or appointment of arbitrators, section 5. Dear friends, this is very important. In one of the paragraphs in this judgment, the entire provisions of the Arbitration and Conciliation Act should be interpreted in view of section 5. See how beautiful. Like, what does it mean? Section 5 is the guiding light. Section 5 is the goal. And all the provisions in the Arbitration Conciliation Act should be interpreted in view of section 5. Similarly, all the constitutional provisions should be interpreted in order to give effect to the goals enshrined in the preamble of the Constitution. So, although 8 and 11 allow court to refer parties to arbitration or appoint arbitrators, section 5 limits the court from from dealing with substantive objections pertaining to the existence and validity of arbitration agreements at the referral or appropriate appointment stage. A referral court at section 8 or section 11 stage can only enter into a prima facie determination. That legislative mandate of prima facie determination ensures that the referral court do not trammel, do not restrict the arbitral tribunal authority to rule on its own jurisdiction. Section 5 of 8 in interpreting the extent of judicial interference under 8 and 11 of the Arbitration Act. Section 5 contains a general rule of judicial non-interference. Dear friends, these are all the golden lines which I am going to read. Therefore, every provision of the Arbitration Act ought to be construed in view of section 5 to give true effect to the legislative intention of minimum judicial intervention. So this is how we have to interpret the Arbitration Act. Then the Arbitration Act, next heading is Arbitration Act is a self-contained code. What does it mean? Page 63, para 90. Page 63, para 90. They are referring to one constitution bench judgment, dear friends, in Girnar Traders versus State of Maharashtra. In this case, a constitution bench of this court observed that Arbitration Act is a self-contained code. It is a complete legislation with regard to the purpose for which it was enacted. It is such a self-contained code provides for a complete machinery to deal with the purpose sought to be achieved by that law, and its dependence on other legislation is either absent or minimal. Meaning thereby, the reference to any other statute is absent or it is very, very minimal, because Arbitration Act is a self-contained code. It has everything in itself. This is what they have said. Now moving on to the next heading, dear friends. The doctrine of competence. The most important aspect is page 75, para 131. Page 75, para 131. What is competence? Section 16(1)(6) of Arbitration and Conciliation Act empowers the arbitral tribunal to rule on its own jurisdiction, including ruling on any objections, dear friends, with respect to the existence or validity of arbitration agreement. So arbitral tribunal is an autonomous body. It can decide on any objections raised by the other side. It has the authority to decide. Importantly, the parties have a right under section 16, subsection 2 and subsection 3 to challenge the jurisdiction of the arbitral tribunal on grounds such as the non-existence or invalidity of the arbitration agreement. Though arbitrators are born out of arbitration agreement, but still they can decide about the existence of the validity of the arbitration agreement. The arbitral tribunal is obligated to decide on the challenge to its jurisdiction. Where it rejects the challenge, meaning thereby the arbitral tribunal decides that it has a jurisdiction. What is the effect of it? It can proceed with the arbitral proceedings and make an arbitral award. It is a principle of procedural competence which recognizes the power of an arbitral tribunal to hear and decide challenges to its jurisdiction. Once the arbitral tribunal makes an arbitral award, Section 16, subsection 6 allow the aggrieved party to make an application for setting aside the award under Section 34. Section 16, subsection 5 and subsection 6 further shows that Parliament has completely, dear friends, has completely ousted the jurisdiction of the courts to interfere during the arbitral proceedings. Court can intervene. When court can intervene? Court can intervene only after the tribunal has made an award. Thus, Section 16 is intended to give full effect to the procedural and substantive aspects of doctrine of competence. How, see, this is the heart and soul of competence and competence, dear friends. But how do you find that this is a heart and soul? By looking at various other paragraphs, you will say, oh, this is not that important, or this is not very important to make a point. So you have to work for this, dear friends. Now we are guiding you, we are spoon feeding you at free service. Why do we do so? Because for this, entire team works, because we want to produce a strong bar. We want to uplift ourselves first. When I am going to help someone, I should be in a firm position to help others. So therefore, I need to develop knowledge, develop the skill. And it is always said, when mind is full of knowledge, it is only a storehouse. When that knowledge is shared with others, it becomes a lighthouse. We need a strong bar. We need strong people of India. Therefore, country will be strong. We need many more Vivekananda. We need many more prophets. Therefore, they can live for others. So therefore, even today, we are living for others because it's a great message that we are telling to our people. Good people are there. They are interested in providing service. So make sure that we help everyone. Let us have a harmony in our system. Next, dear friends, what is the heading? Harmonious construction of the Arbitration Act, Stamp Act and Contract Act. Page number 90, para 170 and 171. Page number 90. Para 170 and 171 talks about harmonious constructions. I will sum up this 170, 171 in a few lines. To harmonize is not to destroy any statutory provision or to render in use. That means it is dead or it is meaningless, it is not given effect. You should not do that. What you need to do is, when there are two conflicting provisions in the Act which cannot be reconciled with each other, they should be so interpreted that if possible, effect should be given to both. This is the essence of the rule of harmonious construction. This is very important, dear friends, both in the statute also as well as in our life also. Now moving on to the Arbitration Act will have primacy with respect to the arbitration agreements. Then thereafter we have discussed about object of the Stamp Act is preserved. So let me tell you the relevant paragraphs, dear friends. Since we are running short of time, I will give you the relevant paragraphs. The Arbitration Act will have primacy with respect to arbitration agreements. Arbitration Act is a special law, whereas Contract Act and Stamp Act is a general law. So special law will always prevail over the general law. So in this, the Arbitration Act will have primacy with respect to arbitration agreement. Page number 92, paras 178, 180, 181, 82, 183, 184. These are all the relevant paragraphs. Page number 99. The object of Stamp Act is preserved. Para 205, dear friends. Let me read this. How it is object of the Stamp Act is preserved. Para 205 at page 99. The interpretation according to the Stamp Act by this court in the present judgment does not allow the law to be floated. The arbitral tribunal continues to be bound by the provisions of the Stamp Act, including those relating to its impounding and admissibility. The interpretation of the law in this judgment ensures, see how they have interpreted harmonious construction. The interpretation of the law in this judgment ensures that the provisions of the Arbitration Act are given effect to, while not detracting from the purpose of the Stamp Act. Para number 206. The interest of the revenue are not jeopardized in any manner, because the duty chargeable must be paid before the agreement in question is rendered admissible and the list between the parties adjudicated. The question is at which stage the agreement would be impounded and not whether it would be impounded at all. The courts are not abdicating their duty but are instead giving effect to the principle of minimum judicial intervention in section 5 of the Arbitration Act. The prima facie standard applicable to section 8 and 11 of the Arbitration Act. The purpose of the Stamp Act, which is to protect the interest of the revenue and not arm litigants with a weapon of technicality by which they delay the adjudication of the list. Ultimately, dear friends, Global 2, this is a judgment. Global 2 was overruled by the Honorable Supreme Court in this Constitution bench. Now let me take you to the conclusions. Sorry, Global 2. Global 2. NN, is it? NN. Global. There are two judgments, NN Global 2 are overruled. Let me come to the conclusions, dear friends. That will make you clear. Conclusions is at para 235 at page 108. We are concluding with this, dear friends. The conclusions reached in this judgment are summarized below. I repeat, the conclusions reached in this judgment are summarized below. This is authoritative pronouncement, dear friends. The conclusions are at page para 235, meaning thereby para number 1 to para number 234, they have decided to reach this conclusion. Roots are there, branches are there. Ultimately, this is the fruit of the tree, fruit of the judgment. 235.1. Agreements which are not stamped or inadequately stamped or inadmissible in evidence under section 35 of the Stamp Act. Such agreements are not rendered void or void ab initio or unenforceable. So it is not void agreement, it is not void ab initio, it is such agreements are not unenforceable, meaning that it is enforceable. It is only inadmissible in evidence under section 35 of the Stamp Act. Point number 2, 235.2. Non-stamping of inadequate stamping. Non-stamping or inadequate stamping is a curable defect. I repeat, non-stamping or inadequate stamping is a curable defect. 235.3. An objection as to the stamping does not fall for determination under section 8 or 11 of the Arbitration Act. The court concerned must examine whether the arbitration agreement prima facie exists. Point number 4. Any objections in relation to the stamping of the agreement, any objections in relation to the stamping of the agreement fall within the ambit of arbitral tribunal, meaning thereby arbitral tribunal is an autonomous body. Therefore, it can decide on its own on any objections. 5. Point number 5. The decision in NN Global 2 and SMST estates are overruled, because in those cases they have said it is a void agreement. It is a void agreement, they have said. Therefore, that is overruled. Para 22 and 29 of Gurwar wall ropes are overruled to that extent. So, dear friends, we have discussed in detail between lecture number 82 up to lecture number 86 the entire aspect of this judgment, interplay of arbitration agreement under Arbitration Conciliation Act and Stamp Act 1899. So, with the guiding lectures from 82 to 86, you can make notes and you can refer to the SEC 2024 volume 6 SEC page 1 with reference to those relevant paragraphs. You can do wonders. Ask yourself this question: how will I secure gold medal? That is the right question. Don't ask a wrong question: how will I clear this examination? Ask a right question, you will get a right answer. Once you ask that right question, immediately the answer will come to you. Write quotations for each questions. At the end of the questions, you give your own conclusion. In my humble view, my personal view, way forward, that is the heading under which you can always write down. This is my humble view about this judgment. This judgment ensures economic justice enshrined in the preamble. Preamble our goal, preamble our soul. Write it in AOR examination. What is wrong in it? We need creativity, dear friends. We need creativity in our examination. So therefore, they will also create marks for you. Thank you so much for your patience hearing.